Here's some good Second Amendment news. This week we filed a memorandum in support of our motion for summary judgment in the federal lawsuit against the ATF challenging the ban on the sale of handguns to 18 to 20-year-olds. This is the case here in West Virginia where I'm local counsel, along with one of the country's top Second Amendment lawyers, Adam Kraut, where we're representing the Second Amendment Foundation as well as the West Virginia Citizens Defense League, attempting to reinstate the rights of an important segment of American citizens. You can read the memorandum in full at the blog. It's up at thecivilrightslawyer.com. I'll post the link in the description. Although the Second Amendment right to possess and carry weapons in case of confrontation is supposed to belong to all Americans, right now adult Americans age 18 to 20 are excluded from the entire commercial market for handguns. They may vote, enter contracts, marry. They're even eligible to serve in the military and die for their country, and as they obviously have. But they're prohibited by the federal government from purchasing handguns and handgun ammunition commercially. They can buy rifles or shotguns commercially, but not handguns, which according to the Supreme Court is the most preferred firearm in the nation to keep and to use for the protection of one's house and family. You can look at the McDonald case, quoting Heller for that. Following the Bruin case, if a law restricts conduct falling within the scope of the Second Amendment's text, as the federal government's handgun ban here does, that law is presumed to be invalid and can only be saved if the government demonstrates the existence of a distinctly similar historical regulation that burdened the right to bear arms in the same way and for the same reasons. The correct historical period in examining the public's understanding of the right to keep and bear arms is 1791. Constitutional rights are enshrined with the scope they were understood to have when the people adopted them. That's from the Heller case, and the Second Amendment was adopted in 1791. And of course, those restrictions did not exist. At the time the Second Amendment was ratified, not only were there no laws in any state that purported to limit the rights of 18 to 20-year-olds to purchase handguns for self-defense, there were several laws enacted, including the Militia Act of 1792, that required 18-year-olds to buy and maintain firearms. In fact, being an antique firearms collector myself, I can show you several examples of 18th century flintlock pistols that were in use prior to and during the time of 1791. All right, here's some examples of some 18th century pistols that would have been used by 18 to 20-year-olds prior to and at the time of the Second Amendment in 1791. Everything from big British horse pistols, such as this original one that was used in the U.S. Revolutionary War, would have been carried in a holster on a horse, to more primarily self-defense pistols, which most of them were, such as this British 1754 silver-mounted flintlock pistol. These are all just 100% self-defense guns that were in existence. Many of them were very fancy. It was just a one-shot sort of deal. They would have these beautiful inlays, engravings, not even sights. It's just sort of a point and shoot, all meant to be carried concealed. A lot of them were sort of designed to be low drag, but a lot of them were decorated. You can see the gargoyle on this one. And these are all British. I mean, this is our tradition coming into our new country. It was definitely a British tradition to, when you're outside and you're traveling, dangers of the road, the highway, the city, you would have something like this in your pocket. And these are self-defense pocket pistols and engraved with initials, probably given as gifts. And these are all different periods of 18th century British self-defense pistols. So this is absolutely our historical tradition. Everything from mostly private self-defense through pistols being used in the military by 18 to 20-year-olds. And here's an American example using some British pistol parts, but recrafted on the American frontier in Virginia to be used in the 1770s by American frontiersmen. This particular gun was actually owned right here in the Greenbrier Valley by a guy named William Dyer, and he used this pistol to fight in the Battle of Point Pleasant in 1774 here in West Virginia. This was thereafter used in the American Revolution. So pistols have been an integral part of American history, and 18 to 20-year-olds were not excluded from that. The government directs the court to look at laws that were adopted later in the 19th century, late 19th century, and beyond to justify their handgun ban. The Supreme Court has already said, however, that 1791 is the appropriate period. Even at the time that the 14th Amendment was ratified in 1868, only 2 states in the entire country had a ban like the handgun ban. It would be another 5 years before another state adopted such a law. The ATF cannot point to any historical tradition that could justify the federal government's attempt to deviate from the plain text of the Second Amendment. Therefore, in this lawsuit, we're asking the federal court to declare the federal handgun ban unconstitutional. I look forward to providing an update as soon as we receive a ruling from the federal court. As always, thanks for watching. Make sure to join and support some of these important organizations, such as the Second Amendment Foundation, and if you're in West Virginia, the West Virginia Citizens Defense League, which is a fantastic organization that does great work. Remember, freedom is scary. Deal with it. I'll see you next time.